Thank you for joining us. I'm Greg Katsas. Our topic for this panel is the extent to which judges can or should participate in activities of legal organizations such as the Federalist Society. This question came to a head in January when the Committee on Codes of Conduct of the Judicial Conference circulated within the judiciary a draft advisory opinion concluding that the Code of Conduct prohibits federal judges from being members of the Federalist Society. As a longtime member of the society, I became deeply concerned with the proposal, as did many other judges. Hundreds of judges wrote or joined letters opposing the proposed advisory opinion. Bill Pryor, Amul Tapar, Andy Oldham, and I drafted and organized one such letter that was signed by over 200 judges. Many other judges submitted their own individual letters. The questions addressed by the draft opinion turn on three canons of the Code of Conduct for federal judges. Canon 4 generally permits judges to engage in law-related activities, and one of its subsections more specifically states that judges may become members or leaders of organizations devoted to law, the legal system, or the administration of justice. On the other hand, Canon 5 prohibits judges from becoming involved in the activities of political organizations, and Canon 1 requires judges to preserve the integrity and independence of the judiciary. The draft opinion addressed how these rules might apply to three prominent organizations: the Federalist Society, the American Constitution Society, and the American Bar Association. It implicates at least four different kinds of involvement: membership, leadership, financial support, and participating in the organization's programs and activities. In past advisory opinions, the committee had advised that judges could join the ABA and the ACS as members, that judges could not assume leadership positions in the ACS, and that judges could make financial contributions to the Federalist Society. The proposed opinion would have changed course, at least in part. It opined that judges could not join the Federalist Society or the ACS as members, that judges could join the ABA as members, and that judges still could participate in the programs of all of these groups. In July, the committee withdrew its proposed opinion. Committee reverted to its past guidance, and it urged judges to be vigilant in making individual judgments about what activities to engage in. We have a very distinguished panel to address all of these issues implicated by the draft, now withdrawn opinion. Professor William Hodes is an emeritus professor at the Indiana University School of Law, where he taught for more than 2 decades. His academic interests include administrative law, civil procedure, constitutional law, federal courts, and especially professional responsibility. He's a co-author of a leading treatise on professional responsibility, The Law of Lawyering, which was first published in 1985. He was the co-reporter for the ABA Model Code of Judicial Conduct, which was adopted in 2007. Professor Hodes graduated from Harvard College and Rutgers Law School. 27 years after graduating from law school, he clerked on the Supreme Court for Justice Ruth Bader Ginsburg. Judge Tom Griffith served on the Court of Appeals for the DC Circuit from 2005 until September 2020. Judge Griffith graduated from Brigham Young University and the University of Virginia School of Law. He served as legal counsel to the United States Senate from 1995 to 1999 and as general counsel of BYU from 2000 to 2005. As a judge, he taught courses at Brigham Young, Stanford, and Harvard law schools on subjects including presidential power, judicial process, and the role of Article III judges. Particularly relevant for this panel, Judge Griffith served as the DC Circuit's representative on the Code of Conduct Committee until his retirement from the bench. Judge Bill Pryor is the Chief Judge of the Court of Appeals for the 11th Circuit. He graduated first in his class at Tulane, where he served as editor-in-chief of the Tulane Law Review. He then served as a law clerk for Judge John Minor Wisdom of the Court of Appeals for the 5th Circuit. He was Attorney General of Alabama from 1997 to 2004. From 2013 to 2018, he served on the U.S. Sentencing Commission and was its acting chairman from 2017 to 2018. He's a member of the American Law Institute and an advisor for the Restatement Third of Conflicts of Laws. He's co-author of a leading treatise on judicial precedent. He's published in leading law reviews, and he's a visiting professor at the University of Alabama School of Law. And as I mentioned, he was involved with me and two others in drafting a letter opposing the draft advisory opinion. Without further ado, I will turn the floor over to Professor Hodes.
Thank you very much, Judge. I'm going to provide somewhat of a backdrop to the further discussion about the opinion that was mentioned. The title of our panel is Freedom of Association in the Legal Profession, but as you've already heard enough to know that our focus is really on judges, the freedom of association of judges. For example, I'm the only person on your screen who's not a judge. The freedom of association of judges, in turn, is really shorthand for regulation of the extrajudicial activities of judges in their private and sort of semi-private off-duty activities. And like so much in the law, this regulation is really a balancing act. On the one hand, it really is necessary to maintain the independence and impartiality of judges by removing them from direct participation in the hurly-burly of everyday politics, of everyday social strife of various kinds. But on the other hand, it's important not only to avoid having judges completely isolated from the communities in which they work and live. I mean, there would be nothing that would be the sort of essence of mystifying the law to make judges even more removed from the way they are sometimes perceived. And therefore, we not only don't want to remove them completely from our communities, but it's actually an important value that's reflected in these codes to encourage judges to contribute to social discourse. But the caveat is always in ways that it doesn't interfere with their judicial duties, which are, of course, their main event. The key, one of the key being, of course, to avoid having judges involved in so many extrajudicial activities that they generate frequent and frequently successful motions to disqualify. Now, I should also add that this subject is important, I think, for the presumably large number of viewers and listeners who are lawyers rather than judges. And the reason for that is just as it is obvious that the restrictions, the very well-known, well-accepted restrictions on judges receiving ex parte communications instantly creates in lawyers a duty not to engage in those kinds of communications. All of the rules that we're talking about here about restrictions on what judges can and cannot do in their extrajudicial activities create an obligation in lawyers to be aware of these, to know how they're interpreted, so that lawyers won't draw judges into inappropriate conduct or dicey situations. For example, inviting judges to be the headline speaker at some kind of charitable fundraising event, inviting judges to be character witnesses, which is not allowed, and so on, that lawyers need to be aware of those as well. Now, as backdrop to the specific that you've heard is going to be discussed, I'll note that just as almost all lawyers are subject to some version of the rules of lawyer ethics that are derived from the ABA model rules of professional responsibility, almost all state judges are governed, regulated by some version of the ABA Code of Judicial Conduct, a model code of judicial conduct, which was last fully revised in 2007, as Judge Katsas mentioned. And almost all federal judges are regulated by the Code of Conduct for United States judges, which was not developed by the American Bar Association, but was developed by the Judicial Conference of the United States. Now, the two judicial codes share most of their stated goals, most of their stated assumptions, and a lot, but definitely not all, of their language. The chief distinction between the two, and I think this may be important when you get into that detailed opinion later, the chief distinction between the two, aside from the fact that the federal code, for obvious reasons, has no regulations about judges campaigning for judicial office and so on, the main difference is that when the code of the CJC, as it's called, was revised, there was a deliberate move to mirror or mimic the lawyer codes in providing sort of black letter enforceable rules followed by comments, whereas the federal code maintains the stance that of the old state code, which doesn't have black letter text as such. It has a series of canonical propositions, and they are typically stated almost exclusively in should, judge should or judge should not, whereas the ABA's model code, the CJC, for state judges almost always, in virtually every instance, uses shall or shall not, and of course has consequences for enforcement, for interpretation, and so on. Now, all of the codes, the lawyer codes and the two judicial codes, are all intended in the first instant for self-regulation, that judges will talk to each other, will talk to themselves, and be guided by what is in there. But in addition, there are regulatory agencies that will enforce these when necessary. And in addition, there is a robust market for advisory opinions in all of those settings. They have more or less, as the case may be, bindingness or persuasive effect. They provide more or less, in some instance, of a safe harbor. If an opinion says it's permissible to do X or Y, lawyers or judges can rely on that to greater or lesser extent. Now, I'm going to close and turn over to the specifics by flagging what I see are the two main landmines that arise in applying or interpreting or writing opinions about the two these now focusing on the two judicial codes. First, I should say that it is really hard to fault the stated goals or the stated core assumptions underlying either the federal or the state judicial code with respect to judicial activities, at least as a general proposition. As I've already indicated, I think the key to both is creating public confidence in what are referred to in the state code as the three I's, typically in the federal code, two of the I's, which is independence, integrity, and impartiality. And this, in turn, it is postulated, soon stated, creates, if these are maintained, if the public maintains its confidence in the judiciary, this will create respect for and confidence in the rule of law generally. And that is why these provisions often form the backdrop for disqualification of judges. After all, what losing litigant or his friends or his family in the community could possibly have respect for a ruling from a judge who was a member of the board of trustees of the hospital or whoever it was who had just bested him in litigation. So those are all, the necessity for these rules is clear, but there are these landmines, as I said. The first is how do we determine what it is, how the public will react? What does the public think about this or that activity? Are the rules drafters, the opinion writers, are the regulators just projecting their own views about what is acceptable and what acceptable and simply ascribing to that? Well, if the public knew that, they would never have confidence in the legal system. That's a possibility. That cannot be an acceptable way to run a railroad, but neither can simply taking a poll of the public and say, well, what is it that most concerns you about judges? Because I think, and the same is true with lawyers, we might not find that the profession would be willing to countenance what it is that the public wants in that sense. Now, the test under the CJC, the state code, is usually stated as whether the three I's, quote, might reasonably be questioned. Now, that sounds like an objective standard, but who gets to set the reasonableness standard? By sharp contrast, the comparable test, and this is one of the main differences in language, the comparable test in the federal code is whether this or that would create in reasonable minds, with knowledge of all of the relevant circumstances, that a reasonable inquiry would disclose a perception of the judge's ability to carry out judicial responsibilities with integrity and impartiality and competence would be impaired. That is a huge difference, and I think you'll see that reflected. The second one, is very quickly, is that both judicial codes permit more or less engagement with various organizations or judicial activities, depending upon whether they are classified as purely political, chiefly in the electoral sense, at least in the CJC, or whether they are law-related or not, including law-related or non-law-related charities, for example. The defining language was changed in the 2007 revision of the state code to these organizations or organizations that are concerned with the law. Whereas in the federal code, it remains as it was in the state code, and that is that it deals with organizations who are concerned with improvements in the law. And to me, that is a huge difference, very, very loaded concepts. So I'll conclude then and just say that although, as I've said, there must be rules in this area of putting some restrictions on judges in their, whether they're elected or appointed, on their activities. The broad and necessarily somewhat vague ways in which they're stated and the resulting difficulties in interpretation and application create, unfortunately, opportunities for controversy, strife, and sometimes mischief. And that, of course, is my segue to the panel's discussion of the exposure draft that was mentioned. And on that, as was said, Judge Tom Griffith is the leadoff hitter.
Thank you, Bill, and thanks for that very helpful background. I hope I'm not giving short shrift to your brilliant presentation. To sum it up by saying it's absolutely imperative, and this is obvious, but it needs to be said, it's absolutely imperative that the public have confidence in the impartiality of the judiciary. It just has to happen. Now, in some bad form, I'm going to quote myself as I begin this, because I tried to make this point to the Senate Judiciary Committee in support of Justice Barrett's confirmation hearings. I thought this is an audience that needs to be reminded of this. And so here's what I said. A recent survey found that over 2/3 of the American people believe that Supreme Court justices base their decisions primarily on the law and not on politics. In light of that, there is something deeply disturbing about much of the debate surrounding judicial nominations in our nation. Many political leaders and pundits assume that a judge will cast her vote based on partisan preference. Such explanations, typically made for short-term political gain, do much harm. They undermine public confidence in an independent judiciary, which is a cornerstone of the rule of law. The rule of law is a fragile possibility that should be more carefully safeguarded by our leaders. Now, there weren't many senators there that day. It was day 4. I get it, but I felt that needed to be said. And now, even more poor form, I'm going to quote myself again in the final opinion I wrote, serving as Judge Katz's colleague on the DC Circuit. And this was in the Flynn case. I wrote a concurring opinion. I'm just going to read one paragraph from it. Obviously, there was lots of attention paid to General Flynn's circumstances, lots of commentary. And here's what I was hoping was a contribution to the discussion. In cases that attract public attention, it's common for pundits and politicians to frame their commentary in a way that reduces the judicial process to little more than a skirmish in a partisan battle. The party affiliation of the president who appoints a judge becomes an explanation for the judge's real reason for the disposition, and the legal reasoning employed is seen as a cover for the exercise of raw political power. No doubt there will be some who will describe the court's decision today in such terms, but they would be mistaken. There are 2 central issues in this case, both far removed from the partisan skirmishes of the day. The resolution of those questions involves nothing more and nothing less than the application of neutral principles about which reasonable jurists on the court disagree. Okay, enough of quoting myself. I think the dispute over advisory opinion 117 of the Committee on Codes of Conduct is the result of two large forces at play in our nation's political life that require constant evaluation and reevaluation of the proper scope of extrajudicial activities. I'm not a political scientist, but here's my take on what's changed. Why is it necessary to constantly reevaluate judges' activities in light of the principles that Bill Hodes explained so well to us? First of all, the expanding role of government regulation into every nook and cranny of American life has the effect of politicizing areas of activity never before thought to be partisan. So the first force at play, I believe, is the expanding role of politics because of the expanding role of government. Second, the judiciary has too frequently stepped outside its constitutional lane and played the role of policymaker. If judges are going to make political and not legal decisions, it's only natural, it's to be expected that they will face the type of scrutiny the electorate demands of its representatives. As Justice Breyer puts it, judges will then be seen as, quote, the political junior varsity, end of quote. We saw that troubling type of scrutiny in Justice Barrett's confirmation hearings, which at times seemed like a referendum on the wisdom of the Affordable Care Act and not its constitutionality. I'll maybe in question and answer, I'll come back to another point that I think is particularly important for those of us in the Federalist Society. Now, about proposed advisory opinion 117. I was in the room where it happened, okay? And I want to tell you from my perspective, it was not an effort by partisans to thwart the work of the Federalist Society. I was opposed to 117. And yet, in my view, 117 was a good faith wrestle with a new circumstance that's brought about by those two forces that I referred to. It was a reaction by the committee. It was not an initiative. It was a reaction to persistent questions over the years from various judges around the nation. The committee put off those questions for a number of years, but then decided that those questions merited study and a recommendation. Now, a point of clarification. Judge Katsas mentioned this at the outset, but I want to double down on it because I think there's, at least in the media reporting that I saw, I think there was some misunderstanding about this. The proposed recommendation was not a recommendation that judges not participate in events like we're participating in right now. It recognized that that's valid and important, and was not a recommendation that judges not participate in those events. The recommendation involved membership and leadership alone. As the committee undertook its study, the Federalist Society and the ACS, the American Constitution Society, it was apparent from my vantage point that many members of the committee were unfamiliar with these organizations and their aims and their operations. So there was actually a long education process that took place over many months and with much discussion and input from all members of the committee, some of us who had long been affiliated with the Federalist Society. So maybe you can say we didn't do our maybe we didn't do our part. Maybe we didn't make it clear. I think we did, but maybe we didn't make it clear how unique the Federalist Society was. And from that discussion, it was understood that the ABA was involved in political matters. I mean, that's obvious. That was one of the reasons I resigned my membership from the ABA many years ago. But many members of the committee were persuaded that a judge could insulate herself from those ABA matters by joining the judges section, which took no part in making those policy judgments and recommendations. It was also understood that the Federalist Society and the American Constitution Society have very different models. It was understood that the ACS is actually involved in political matters. Their website announces that. They support certain judicial nominations and legislation. And of course, the Federalist Society does neither. I think that was understood. from my perspective, it was hard for some of us to convince many members of the committee that the Federalist Society was not involved in partisan matters because of the media reports. The media reports in two ways. First, the media reported that officers of the Federalist Society were deeply involved in the Trump administration's strategy for judicial nominations. And the point was made that they were acting in their individual capacity, not as officers of the Federalist Society. That didn't seem to be persuasive to my colleagues. The other media report that hurt was that undermined the argument that the Federalist Society was not partisan. Was the coverage of events such as Justice Gorsuch's speech at the National Convention a couple of years ago. And the media reporting of that portrayed it as partisan. So is a heckler's veto at work here? Perhaps. There's some element of that. But from what I could tell from, again, being in the room, it was those media reports tying the Federalist Society to the Trump administration that led to the proposed advisory opinion that you saw that garnered so much controversy. It was withdrawn and defeated, and bravo, bravo. I think I think the world of my colleagues who had different views on the matter than I did. I think this is my surmise. I think that when the advisory opinion was issued, the proposed advisory opinion was issued, that they underestimated how this advisory opinion, if it became binding, how it would be used by partisans on both sides, particularly in future confirmation battles, that it could be used as a cudgel against nominees, either from a Republican White House or a Democratic White House, and from what I could tell, when it became clear that was the case, I think that had a lot to do with the committee's overwhelming decision to withdraw the opinion. So, with that description, I will turn the time over to Judge Bill Pryor.
Thanks, Tom. I'm pleased to talk about this topic and explain why Judge Katsas and I and hundreds of other judges successfully urged the Codes of Conduct Committee to withdraw advisory opinion number 117 and to table further consideration of it. The exposure draft of that advisory opinion conflicted with the Code of Conduct for United States judges. It reflected a misunderstanding of the Federalist Society, and it applied a double standard that raised serious constitutional concerns. Let's start with first principles. Federal judges are not hermits, and the Code of Conduct does not require them to be. And lawyers and the American people should not want them to be. The commentary to Canon 4 states that judges should not become isolated from the society in which they live. And Canon 4 allows judges to serve as members, even officers, of nonprofit organizations devoted to the law, the legal system, or the administration of justice. Judges are encouraged to teach and lecture and to publish scholarship. The commentary to Canon 4 also encourages judges to contribute to the law through membership in a bar association, judicial conference, or other organization dedicated to the law, including those focused on revising substantive and procedural law. The committee previously recognized that federal judges may join and donate to both the American Constitution Society and the Federalist Society. What changed? The exposure draft alleged that the Federalist Society advocates for factional policy positions instead of general improvement of the law. And the draft asserted that the public would view judges holding membership in the society to hold, advocate, and serve conservative interests. The draft also stated that membership in the society implicated the broad prohibition of political activity in Canon 5. This was all nonsense. The most that the committee could offer as proof that the Federalist Society promotes policy positions is that it describes itself as a group of conservative and libertarians dedicated to reforming the current legal order, and that it promotes appreciation for the role of separation of powers, federalism, limited constitutional government, and the rule of law in protecting individual freedom and traditional values. But these principles lie at the foundation of the American constitutional order that federal judges are sworn to support and defend. The draft could not identify a single policy position taken by the Federalist Society, which has never lobbied a policymaking body, filed an amicus brief, or otherwise advocated any policy change. Instead of taking specific legal or policy positions, the Federalist Society encourages open, informed, and robust debate about legal topics. Every current member of the Supreme Court, even before the three most recent appointees joined it, has participated in at least one Federalist Society event, as have hundreds of current and former federal judges and a wide range of legal scholars and attorneys. The committee has approved, and rightly so, judicial membership in organizations that advocate far more specific legal positions. For example, it has approved membership in the American Law Institute, which seeks to clarify, modernize, and otherwise improve the law. The institute, to which I proudly belong, publishes restatements of the law and model codes and advocates detailed changes to many areas of law. And federal judges are regularly involved in all aspects of its work. The exposure draft misunderstood some statements and activities by individual leaders of the Federalist Society, most notably perhaps by Professor Stephen Calabrese or by now co-chairman Leonard Leo, to represent official positions of the society. But when, for example, Professor Calabrese speaks, he does so for himself. And sometimes other members of the Federalist Society strongly disagree with him. I have some experience with this. For example, in 2017, Professor Calabrese advocated increasing the size of the inferior courts, and I published an op-ed in the New York Times that strongly disagreed with his proposal. The same is true for the statements of leaders of other law-related organizations that judges may join. For example, when the president of the American Law Institute speaks, he or she ordinarily does so for himself. I have challenged some of those statements in public lectures, and when I did so, I spoke for myself. The exposure draft also created a double standard. The draft would have continued to permit judges to belong to the American Bar Association, but the ABA, of course, takes positions on many policy questions. It has filed more than 100 amicus briefs in cases about political issues such as abortion, affirmative action, gay rights, immigration, and gun control. And it routinely lobbies Congress. The same is true for many specialty bar associations. The exposure draft used a novel, evolving public perception standard to say that a reasonable and informed public would view judges holding membership in the Federalist Society and the American Constitution Society to hold, advocate, or serve liberal or conservative interests. But it then blessed membership in the ABA because that organization, as opposed to a reasonable and informed member of the public, considers itself to be nonpartisan. So the exposure draft applied its novel standard to the Federalist Society, but did not apply it to the ABA, even though its activities are far more political. The evolving public perception standard requires either a host of discriminatory applications or sweeping and untenable prohibitions. For example, federal judges regularly teach at law schools, but law schools frequently litigate to advance specific legal positions, either directly or through their clinics. If the public comes to perceive certain law schools as liberal or conservative, must judges resign their post as law professors? Surely judges too can be members of churches, temples, and mosques. To suggest otherwise would raise serious constitutional questions. But the evolving public perception standard would logically prohibit membership in any church, temple, or mosque that takes a policy position on topics like abortion, capital punishment, gay rights, and climate change. The exposure draft also committed a fundamental error when it conflated judicial philosophy with politics. Judges may properly and long have identified themselves as proponents of certain judicial philosophies, such as judicial restraint, textualism, living constitutionalism, and pragmatism. Jurisprudential views are not the same as political views. The Code of Conduct uses the term political narrowly. Canon 5 makes clear that the political activities it prohibits involve the work of political parties and candidates for elected office. Judges may write and speak about jurisprudential views and join and participate in the activities of law-related organizations associated with those views. As troubling as the exposure draft was, I'm pleased that it was debated, denounced, and withdrawn. Judges appointed by every administration from President Nixon to the present signed our letter opposing the exposure draft, and many of those judges were not members of the Federalist Society. We owe a debt of gratitude to Judge Erickson, the chair of the Codes of Conduct Committee, for seeking comments about the draft. And the committee should be applauded for tabling the draft by, I'm told, a wide margin. The committee was right to respect the hundreds of federal judges who have concluded that the code does not prohibit membership in this organization with which I have been associated for more than 35 years. That's all I have to say for now before I turn the panel back over to our moderator, Judge Katsas.
Thank you, Bill. Before we proceed any further, I'm going to announce the code for anyone who wishes to obtain CLE credit. I'll do that now, and if you don't have a pen or pencil handy, I'll do it once or twice before the panel finishes. For those of you who want CLE, the code is let me invite all of the panelists to take 2 or 3 minutes if they wish to respond to comments of their co-panelists. Professor Hodes.
Yeah, just very quickly, I had one comment with respect to each of my colleagues that the sort of the dovetail nicely with what I was saying. I agree very much with what Judge Griffith said, that on the face of it, the opinion, although wrong-headed and caused mischief, as I said in my conclusion, proceeded, as far as I could tell, from applying those quite proper principles and core assumptions. But the main thing is they just got the facts wrong. They when they talked about taking positions and trying to make a distinction between the ABA and the Federalist Society, they got it exactly backwards, which is exactly Judge Pryor's point as well. And so I think all of those comments go together. And then as a second follow-up, I thought it was interesting when Judge Pryor also focused on, exactly which kinds of groups it is we are going to either allow or even encourage people to join, judges to join. There was this distinction between political on the one hand and the other. That is fairly easy to see, but then this subgradation of organizations that are concerned with the improvement of the law. Now, there are various, they're both in the opinion and in various places in the comments. Sometimes that little tag phrase that I noted when I was talking about the landmines, sometimes it included and sometimes it didn't include the idea about improvements in the law as opposed to just concerned with the law or concerned with the administration of justice. And I've always thought that, a good example of that is, as just prior mentioned, that the ABA has taken lots of positions on some things. And my recollection is that several years ago, the ABA lost a lot of members when it took a formal position, not just in an amicus brief, but in a formal position on opposing the death penalty. And my question was always, well, if we did away with the death penalty, would that be an improvement or not an improvement in the law? Some people say one thing and some say the other. You can't make that the subject of a rule of ethics if that's your definition of what, quote, an improvement is. That's the substantive law that lawyers and judges of goodwill and litigants are going to fight about.
Yeah, so I want to associate myself with everything Judge Pryor said. Bill, that was brilliant. I think the process actually worked well because of the outpouring, because of the debate it spawned, because of the outpouring of commentary, which was excellent commentary. Because I opposed 117, it's going to sound a little bit strange to defend one aspect of it. I'm not defending the aspect of it, but so much that the members of the committee did seem to think that the judges section of the ABA was something of a safe harbor that would allow a judge to be part of the ABA and remove herself from the overtly political activities of the ABA. Again, that wasn't particularly persuasive to me, but I think that's a reasonable argument. So I think, to me, here's the tough issue, and you've spotted it. Because the public perception is so vital to maintain the role of the judiciary, what do we do when there's this persistent narrative that's coming from New York Times and other places, right? That has identified the Federalist Society as a partisan, right? It's a partisan, and so to me, it's not so much a legal issue. I think the legal analysis that you offered is perfect, and I agree with it, and tried to make that point to my colleagues. But to me, it almost comes down to sort of a prudential issue. And I'm not certain exactly what to do about that, except to realize that there is a burden that we have to carry to make certain that we don't give our opponents cudgels to use against us, easily. And I'm not suggesting that's what happened here, because again, I'm not going to give in to the heckler's veto, right? I'm not going to give into that. But I just will report to you that it was those sorts of media reports that influenced a lot of the thinking of good, careful judges who were really concerned about this issue of how do we preserve public confidence in the impartiality of judiciary. And so while this issue, 117 is dead and tabled and gone, the larger issue, I think, remains. In a time when everything has become politicized, what should a judge do to make certain that she does not create doubt in the minds of the public as to her impartiality? And so that's the challenge, and I don't have the answer to it, but I think it's an ongoing challenge. I think it's an important one.
Yeah, I think the problem for the committee, though, was that it allowed factional interests to define organizations instead of looking at it the way judges are supposed to look at it objectively. And if the concern is one about how a reasonable member of the public would perceive these organizations, the reasonable member of the public is one who knows all the facts,
Right.
and knows what is a partisan characterization, what is spin, what is fake news, if you want to call it that, and what is not. And that was one of the fundamental problems, I think, fundamental errors that the committee committed in that draft.
So here's where.
So,
Yeah.
what the New York Times says is one thing perhaps to be considered, but it can't define what the Federalist Society is. And to a large degree, then the committee then saw that its own error when it was evaluating membership in the ABA and the separate division for judges. It recognized what the ABA had set up and what all the actual facts were surrounding that. I'm not condemning membership in that part of the American Bar Association, and I think there are good arguments for judges being able to do that. But they weren't applying the same standards to both organizations.
Yeah. So one thought and we'll get to questions and answers. I know we want to do that, but I don't think I'm oversimplifying things to say. There's sort of two narratives that have developed about what was going on in the Code of Conduct Committee, and one of the narratives is that it was a partisan effort by forces outside the committee to take on the Federalist Society. And if that was in fact the case, then it really wouldn't matter what the members of the committee thought about public perception, right? There's another narrative. That's what I'm trying to represent is the other narrative from what I could see, and that is that actually was not what was going on. That it was grappling with a novel issue created again by these new forces. And in that, if I'm right about that, and I may not be right, if I'm right about that, I think it is instructive that a group of, I don't remember how many members of the committee we have, 14, 15 members of the committee could look at this and in the first instance, despite arguments to the contrary, conclude that the Federalist Society was a little too cozy with the Trump administration. That's something we ought to take into account, right? Now, if it was just partisans going after the Federalist Society, who cares what they think? But I don't think that's what was going on. So I think if there's anything there's a lot that we can take away from this experience. One of them is, I think there is a burden on us who are associated with the Federalist Society to kind of bend over backwards to avoid creating those appearances, and only we can decide whether we do that. But I do think in the court of public opinion, in the court of public perception, we do have a burden that I think we ought to take on, and maybe we can do a little better there. I don't know.
Well,
let me put one question on the table.
Okay.
Go to the audience, which is, Bill, we distinguished between organizations that take positions on very specific partisan or policy issues like the ABA, you name it, death penalty, affirmative action, gay rights, they're in everything. Versus organizations like the Federalist Society, which take positions on things that seem either much more general or much more methodological. So supporting originalism, separation of powers, the American founding, whatever. Society's pretty contentious right now, and there are a lot of things that might have seemed like once upon a time they were common ground among all of us. I mean, are we ever going to get to a point with, you have so many people like tearing down statues of Thomas Jefferson that being pro-American founding starts to look more like taking a position on a contested issue? And what's the right answer on that?
Well, you're right. To a large degree, the polarization and increasing partisanship do make what were in previous generations perhaps common or consensus views seem more divisive. But at the end of the day, federal judges are still sworn to uphold the Constitution of the United States and the laws and treaties of the United States, and that reflects a particular legal tradition and constitutional order, which are absolutely the stuff that the Federalist Society has promoted and continues to promote from day one. Let's look at how the organization named itself. It named itself after the proponents of the United States Constitution. It chose as its logo a silhouette of a bust of James Madison, the founder, who is often called the father of the Constitution. If federal judges can't do that, then at what point does everything about the oath itself, the judicial oath, become partisan and political? I take Tom's point about the society having an obligation to maintain its mission and to not become embroiled in politics. But by the same token, the society has, from its earliest days, invited and heard speeches from presidents of the United States. I remember when President Reagan spoke at what I think was the very first lawyers' convention at the Mayflower in Washington. I remember President George W. Bush speaking to the society at Union Station, and I'm sure that the society would welcome speeches really by any American president. It's had speeches by cabinet officers of at least virtually every administration I can remember since the founding of the Federalist Society, and so long as those speeches and events are focused on the mission of the society and the topics that it regularly debates and speaks about.
Okay, we have a little more than 15 minutes left, so let's go to questions. If I am doing this right, I will recognize Mr. Carl for a question. And
Can you hear me?
Please unmute.
Can you hear me?
Yes.
Okay. Mr. Griffith mentioned that public perception might be an important thing to consider in determining what judges should do. And then he mentioned the New York Times, and all of a sudden I thought, we got a problem here, because if the New York Times and the Washington Post, for example, consistently write articles or suggest that the Federalist Society is an advocacy group or is, unabashedly conservative, doesn't that create the problem that the public has a perception and therefore judges need to get out? I mean, are we going to leave that to the newspapers?
Great question. That's the heckler's veto question. So who wants to handle it?
I raised the point. I think you're right. That's part of the challenge here, and that is heckler's veto. And we can't let the editorial board of the New York Times decide, by the standards by which we live. All I'm offering is that's part of the reality of it. It's a prudential question, right? It's it is important that the public perceive the judiciary to be impartial and independent. And so we need to do all that we can to make that point. And I'm telling you from my perspective as one who was in the room, what at least in the first go around, what was persuasive to many of my colleagues was the consistent reporting that the Federalist Society was deeply involved in the selection and nomination and confirmation of Trump administration judges. That was the story that seemed to be persuasive.
Well, and so individual members of the society engaged in those kinds of activities, not on behalf of the society, but on behalf of themselves. But it was okay for the committee to bless membership in the ABA, which has the standing committee on the federal judiciary that has rated federal judges for half a century or more.
Yeah, no, I'm not going to defend it. I voted against it and worked against it. But I'm telling you that was from what I could tell from my perspective, that was the dynamic. And so now what do we do with that? Maybe we just reject it. I think we can learn from it. I think maybe there are things that we can do to diminish that perception.
But you agree with the questioner, though. We can't let the newspapers define it. I mean, partisan newspapers are not a new phenomenon in American history. They were every bit as partisan, if not more so, at the time of the founding itself.
Yeah, no, I hope I made myself clear. Maybe I didn't. We can't allow a heckler's veto to work here. Neither can we disregard the views of many people that we are partisan. And so now what do we do? The question is, what do we do about that? Is there anything we can do about it? One thing we don't do is compromise our principles, right? But are there things around the edges that we can do? Because I tell you, I made the argument, though these are individual officers acting, this is not the Federalist Society. And that seemed not to be believed.
I'll just add one more comment from
Well, I think Bill wanted to say something.
Oh, I'm sorry. Go ahead.
Yeah, I just wanted to say that this concrete example, I think, brings back into focus that difference in language in the state versus the federal code that I mentioned before. And I want to give it again, and it does a lot. The federal code, being much better in this aspect, does give some room to hold people's feet to the fire. The standard in the state code, and there was a huge argument, by the way, during the drafting of that as to whether we shouldn't go to the federal language, but the state CJC language is in testing out all of the public perception is in disqualification and other areas, whether something or other might reasonably be questioned. Impartiality, conflict of interest, disqualification, it might reasonably be questioned. The federal standard is whether the same this or that would create in reasonable minds, not only with knowledge of all the relevant circumstances, but knowledge of the relevant circumstances that a reasonable inquiry would disclose. And so I think one way of pushing back on this, especially when you're operating in the federal realm, is, did you make, where's your reasonable inquiry? Why are you accepting, whether it's the New York Times or anybody else, this perception that such and such happened? Tell me the circumstances, tell me what you did to find out what the circumstances were, and use that to advantage.
Let's take another question. Judge Radler. Chad?
He may be muted.
Can we get Chad Radler unmuted?
Yeah, Judge Katsas, thank you very much. I wanted to say to Judge Griffith, congratulations on your terrific service to the bench. Thank you for your many years of service, and best of luck with your future endeavors. I joined the letter that Judges Pryor and Katsas and others put together because I was really worried about the slippery slope problem here. Judge Griffith, you noted that the proposal was targeted only at membership in the organizations, and that may have been the case. But I did worry that once that marker was laid, that with the camel's nose under the tent, that the next effort is to limit some kind of participation in certain types of Federal Society events or ABA events and other events. And I thought it important to leave some room for judges to operate outside of their core legal work. You acknowledge that concern too. And so my main concern was ensuring that judges are able to participate in society as much as possible. I'm realizing their limitations, but I was concerned about the next step in the process. And I don't know if there were any discussions regarding that point, but thank you again for this great panel.
Okay. Yeah, there was never any discussion that I recall that would have gone so far as to limit participation. That wasn't part of it. Now,
well, tell me this, what about the notion that it's okay for judges to participate in the activities of a law-related organization by the Federalist Society, but it's somehow improper to belong to it? It's hard for me to understand what the basis for that distinction would be.
Again, so you're putting me in a position where I have to defend something I disagree.
I understand. I'm just asking, was there discussion of that?
I'll try and represent the thinking as best I can. I was thinking that I disagreed with, but I think it was, again, my primary objective today is to push back on the narrative that there was something nefarious and partisan going on, because I'll die on that hill. But I think there was something mistaken going on, but it wasn't nefarious. I think the thinking was that membership is embracing a set of ideals that I think the committee mistakenly misunderstood the difference between a judicial philosophy and a partisan point of view. Whereas participation is, I think everyone was aware that on Federal Society panels, there are all sorts of views presented, and that you're not necessarily endorsing the ultimate aims of the society. You're just participating in an event. I think that was the thinking there. Now, let me say, Bill Hodes made an excellent point that underscores something that Judge Pryor was saying. Is, look, the law is on the side of the status quo that we have now, and that's not my point. Is a different point. My point is, okay, the law is, I think, pretty clear on this, but there's another battle. I hate to use the warrior mentality, but there's another battle going on here, and that's for the public perception. And I think we need to wage that war. And I don't think we do it successfully just by patting ourselves on the back and saying we're great guys, we're doing wonderful things, great men and women. I think we need to wade into the public sphere and carry on that discussion there. And it's almost entirely an educational matter, because I think there's a lot of misperception about what's going on out there. So,
all right, next question, Michael Rossman.
Can you hear me?
Yes, go ahead.
Great. Thank you, Judge. I think it was mentioned earlier that unlike the Federalist Society, the ACS does take political positions. Is it possible that the draft opinion was wrong about the Federalist Society, but right about the ACS? And in our rush to condemn the opinion, did we overlook that?
Yeah. Well, I think the problem with that is if it was right about ACS, then it was also wrong about the ABA. Because I think that I'm not an expert about the activities of ACS. I'm familiar with some of its activities and have looked at it and certainly considered it when we were working on our letter. But I think it'd be pretty hard to argue that it is anywhere near as political as the American Bar Association. which takes far more specific positions on just a host of policy positions than ACS. And so far as I know, I mean, what ACS really focuses on are perhaps more specific policy positions about contested issues than the Federalist Society, but it seems always to be about the law and the judiciary.
Yeah, as I understand, ACS takes positions on judicial nomination, supports or opposes. So Bill, can I ask you a question? So on the ABA, what do you do with the judges section argument? Because that was the prevailing argument, as I recall, on the committee, that the ABA.
I guess I'm in the position that you are in that I resigned from the American Bar Association many years ago, too. And I do think that it's problematic, but I think they're pretty good arguments for why a reasonable observer would perceive the participation in the judicial division as insulated and different, and would not raise questions for judges.
Tom, do you really think that all of your colleagues who put out this letter would have said everything is fine and dandy if the FedSoc just tells judges that they have a separate membership category? Judicial.
Are you asking what I think the committee would have done, or maybe I didn't understand the question?
Yeah. So I mean, FedSoc creates a separate membership category for judges. Problem solved on their reasoning or not.
Based on the reasoning of the draft opinion, you would think that, right?
You would, but based on the optics of it and the hand-wringing of it as to FedSoc, I'm not sure.
Yeah, I was going to say when this was just raised, when I first read the opinion, I thought that caveat was the weakest part of the opinion, because exactly as just Katzis says, any organization, you could just simply create this and say, never mind, don't look over here, but you haven't changed its form over substance in a big way. So I think that didn't really do the opinion any favors by making it turn on something that really is really just a matter of putting an extra star on your membership card.
Well, and as I understand it, a member of the committee just happened to be the chair of the judicial division of the American Bar Association. I think talking about perceptions.
I think there was more to it than that, Bill Hodes. As I recall, and whenever I say I recall, that's a red flag. But as I recall, the ABA forbade judges from being part of their is it House delegate assemblies or whatever the policymaking branch is, that a judge could not be part of the policymaking branch. So they tried to insulate judges in that way. They're a separate section, and they also have no say in making the decisions about these highly political issues.
That's a fair comment. I didn't recall that, but I'm sure you're right.
All right. We probably have time for one more question. So Nathan N.
Hello, can you hear me?
Yes, go ahead.
So it's a great panel. I have a couple of questions or thoughts I'd be curious to get your reaction to. I'm not sure that a judge being a member of the Federalist Society or the ACS tells you very much that you wouldn't know just by the party the president who appointed them came from. I mean, it's hardly a man's bite dog situation for a Republican president to remember a judge who is a member of the Federalist Society or, broadly speaking, has those types of views. So I'm not certain why a judge's membership in such an organization tells you something that you wouldn't kind of assume to be the case in most situations. And then relatedly, to the extent that it does give you additional information, I'm wondering why that's such a bad thing. Judges are obviously human. They obviously have priors, so to speak. And why, maybe I'm just fighting the hypothetical, why wouldn't we want to know more about the judge's philosophical leanings and so on and so forth?
Who wants to respond?
Ready?
I don't know how much presidential appointment really tells you. I think that the media focuses on it. Judge Easterbrook and Judge Posner were both appointed by the same president, but and both early, and they were both involved in the early development of the Federalist Society. Their jurisprudential views, they were very, very different. And of course, the Federalist Society has always been a forum for the expression of very different ideas about the law. So I don't know that either one tells you that much.
Anybody else? Okay, we are out of time. I'm told we really have to finish on time to make sure the next panel can get started on time. The next panel will be regulating social media. It will begin at 2:00. I promised a repeat of the code for CLE credit. If you didn't get it the first time, get ready. It is and with that, let me thank all of our panelists for a very interesting discussion. Thank you very much.
Thank you.